in which you said, among other things, there is no rehabilitation in prison. Just help me understand your thinking here, and here's where I'm going, as you can probably imagine. Does that mean that you would be hesitant to send a first-time offender or someone who you think, well, maybe this person could benefit from some rehabilitation?
Senator Josh Hawley wasted no time pressing these judicial nominees on one issue many Americans care about most: violent crime. Rather than asking vague legal questions, Hawley demanded clear answers about whether judges would impose sentences that protect the public, deter repeat offenders, and move cases through a court system facing a massive backlog. The hearing took an especially revealing turn when Hawley challenged one nominee over past comments about prison rehabilitation, leading to one of the most important exchanges of the hearing. Let's watch.
Let me just ask now the Superior Court nominees, so starting with you, Mr. DeBono, and just as Senator Kim did, I just want to go down the line and give you each a chance to respond to a question or two. Let's come back to this notion of deterring violent crime. What is it that what is your understanding of what your role would be, each of you if confirmed to this court, what your role would be in deterring violent crime? Go ahead, Mr. DeBono, we'll start with you. Everybody will have a chance.
My idea of my role, if I'm fortunate enough to be confirmed, is to set a punishment sentence for an individual that's committed a crime that is commensurate with the crime, commensurate with the individual's criminal history, and is appropriate enough to deter that individual from committing further crimes, to protect the public's safety, and to prevent others from engaging in similar activity.
Very good. Mr. DiLorenzo.
I would agree with my fellow nominee. I mean, as a prosecutor, I've made recommendations for incarceration. As a judge, you're better suited because you see at the sentencing, see the whole picture and should look at the whole picture. And part of that is to impose a sentence that will deter this individual, and part of that is sometimes giving a stiff sentence, but a piece of that is oftentimes to provide some sort of rehabilitation to get to the motive of what may have caused a crime, and that's getting some piece of rehabilitation. It may be drug treatment, maybe sort of some mental health treatment. So it's a fashion appropriate sentence that deters this individual, deters others as well.
Judge Goode.
I concur with my fellow nominee. I remember when I was a prosecutor, there was a level of recidivism that was getting frustrating. And so what I would be looking at, if I'm fortunate enough to be confirmed, is has this person done this once, or has this person done this? What was put in place on that first time? Did it work? And what can I do for this person to hopefully prevent recidivism for that one person? Let the community know that I'm trying to prevent recidivism in a larger sense. So be looking at their past record. Is it the same thing over and over again, or is it different things? As many reports as I can get on psychiatric, psychological. If I'm in a juvenile delinquency court, I'd want to know I can't make sure, but how can I come closest to making sure that this person is not going to do it?
Mm-hmm. Very good. Mr. Lane.
Judges play a critical role in deterring crime. The way I would approach it is to apply the standards in the code, as mentioned. But ultimately, it's to avoid outlier sentences, to make sure you're applying a standard that's equal across the people that you see, obviously looking at the individual circumstances. But in the end, it's important that people know that if they commit a crime, they will be punished.
Ms. Macy.
I spent several years as an assistant U.S. attorney focused specifically on homicide cases, and that was just a fraction of my time as in the office. I also spent other years focused on other violent crimes. So violent crime I have seen up close, and I realize how significant of an impact it has on the defendants, the victims' families, the defendants' families, and the community as a whole. So it's a matter that's very important to me. And as a judge, if I'm so fortunate to be confirmed, I would approach my role to addressing violent crime by proceeding fairly in the cases before me, by handling them efficiently so that defendants get their day in court, victims get their day in court, and ensuring that the rights of both perpetrators and victims are addressed and considered in crafting appropriate sentences for the particular case before me.
Mr. Timmer.
I'd echo what my fellow nominee, Ms. Macy, said. During my 7.5 years at the U.S. Attorney's Office, I practiced exclusively in Superior Court, first as a line attorney and then as a supervisor, and so saw firsthand the impact that the judges had on crime in the community, and agree with her that I think steps I can take are to follow the DC code, to impose sentences that are law and with the sentencing guidelines, and to work efficiently to ensure that if somebody commits a crime, is arrested, is charged, that they have their day in court and that day comes swiftly, so that the community can see for themselves that justice has not been denied and has not been delayed.
Judge Goode, let me just ask you, if I could, just on the same topic. In 2022, you were on a panel at Brandeis University in which you said, among other things, there is no rehabilitation in prison. Just help me understand your thinking here, and here's where I'm going, as you can probably imagine. Does that mean that you would be hesitant to send a first-time offender or someone who you think, well, maybe this person could benefit from some rehabilitation? The sentencing guidelines call for, or strongly suggest, prison time, but I don't want to do that because there is no rehabilitation in prison. I want to do everything I can to avoid sending people there. I mean, take me inside your mind here and explain that to me. You just turn on your microphone there.
Sorry about that. Yes, I did say that. What I should have, let me first specifically answer your question, then go back. There's a difference between juveniles and adults, first of all. For juveniles, the standard is rehabilitation, so there is a focus on providing service. Concern about what happens in prison arose from when I was in law school and I actually taught at the Lorton prison. We used to house our prisoners in Lorton, now housed in the federal system. And I saw that conditions were not great for rehabilitation. That's where that came from. Your question was, would that make me hesitate to put someone in prison? No, community safety is my #1 thing. If we can craft a rehabilitation package that makes someone safe to be back in the community, let's do that. But if somebody can't be made safe in the community, then the go is prison.
Let me ask each of you now, again, just the Superior Court nominees, in view of the backlog, the huge backlog that the court is currently facing, just give me your sense of what you would do to help address this huge backlog, how important you think it is, and what your role would be in making sure that these cases are heard, defendants get their day in courts, but also victims get the redress that they deserve. Let's start with you, Mr. DeBono.
If I'm fortunate enough to be confirmed, my role will be to efficiently move my cases, to set clear expectations for the parties, set clear deadlines, be clear from the front about what I expect them to do and be prepared to do when they come to court, and then to show up with the same effort and to be prepared to handle the matters that come before me when they do appear. That way, the cases are quickly handled, they're quickly and efficiently resolved and we're able to get justice for victims and appropriate sentences in place for offenders.
It's necessary to strike a balance between efficiency and fairness, and I've appeared before many judges. I've learned a lot from good habits and bad habits. In order to move things along, what I would do is, as if I were fortunate enough to be confirmed, is I would be the example to everybody in the courtroom. I would go in, and I learned this too. During my clerkship, my judge, William M. Jackson, who sat on the Superior Court, I saw him do this. He was a career prosecutor, and he was on a family calendar. And what he did and what I would do is prepare. He was often, and it would be prepared lawyer in the court law. I've read the pleadings and I'm ready to go. But in addition to being the example, it is essential, as my co-counsel, as my fellow nominee said, that expectations are set. And I found that in my experience, the best way to set expectations is to have a standing order. I found courts with standing orders where it's clear what the expectations are, move efficient courtroom, the courtrooms run efficiently, and there is that fairness. And then also when there are egregious violations, a court has to be willing, there must be consequences when there's repeated egregious.
So I've drawn experience from when I clerked at Superior Court as well. I watched how Judge Harriet Taylor made sure to move a couple of dockets. She had a child abuse and neglect docket, and she had a criminal docket. And I watched the systems that she used to keep up with new case law. We'd get slip opinion, she'd read it, she'd file it, and she'd file it in her head. And I'm still using that to this day. I also have learned as an administrative law judge how to figure out which cases can move quickly and which ones need more time, put the ones that move quickly soon so we can get them resolved as soon as possible without thoroughly delaying the ones that are more complicated, sort of going back and forth between the resolve and the more difficult ones to resolve. And right now we have some of our highest caseloads at the Office of Administrative ever had. So I'm working on that right now. And I schedule hearings every 20 minutes, every 15 minutes, so I can move through those, make sure I can get to trials as quickly as I can. The other thing that I will be focusing on, should I be so fortunate to be confirmed, is courtroom civility. What I found is if I can be the role model for being civil to everybody in that courtroom, then people will follow. When it gets uncivil is when it slows down. So making sure that everybody is polite with each other, respectful with each other, but getting to the facts and getting to the law.
Mr. Chairman, when you mentioned the 100,000 case backlog, that is an enormous number. I would come into the job, if I get confirmed, seeking to be efficient and effective. I've come into several jobs where I had a big backlog when I came in, both at OFCCP and when I was city attorney, and I put a number of norms together right away with my staff. I sought to address cases quickly, fairly and quickly. I wrote a lot of decisions. I tried to rule on everything at once where I could. I published a lot of decisions so people could have an idea where I'm coming from. It could cite to precedent. And I would also be an internal advocate within the court system to move cases. It's extremely important to move cases so that everyone gets their day in court.
In terms of my role, if I'm so fortunate to be confirmed, of addressing the backlog, I think it has to start with preparation on my end of taking the bench, being ready for the cases before me, knowing the facts, having an agenda of what should be covered that day, and holding the parties to that same standard of coming prepared and setting the tone that you expect your courtroom to be run efficiently and for them to be prepared and make progress so that the hearing accomplishes as much as possible. I would draw on my experiences both as a law clerk in DC Superior Court. I clerked for the then Chief Judge Lee Satterfield and was able to see firsthand sort of process and ways to set up systems to approach cases efficiently. And also as an assistant U.S. attorney with very heavy caseloads, I've had to learn how to balance giving the cases the attention they deserve, but also moving efficiently and knowing how to prioritize things. So I would use all of those experiences and create a system on the court to move my cases efficiently.
I draw on similar experiences to my colleague, Ms. Macy. Walking in at the U.S. Attorney's Office, I joined the domestic violence misdemeanor section and was confronted with an enormous caseload, each one of which was deeply important to the person who had been a victim in that case. And so quickly learned how to identify which cases needed work urgently, work efficiently through them, and ensure that justice was done in each case. If I were to be so fortunate to be confirmed, I think my fellow nominees have identified a number of very important steps to take, which I would share. I think one very important thing to do is to communicate with litigants in advance of hearings. What is the judge interested in hearing about? What are the key issues? So that not just me as the judge, but the litigants, the parties, have had the opportunity to consider the issue, come prepared to talk about it, hopefully deal with it all at once. And so one hearing doesn't turn into 2 or 3 or more.
I'll turn to Senator Blumenthal here in just a moment, but I've been advised repeatedly that unless I ask each of you the following question, the sky may fall in, your nominations may not move, hell may freeze over, and the Senate may get nothing done. Although, oh, wait, that's already happening. So maybe we'll risk it, though. Here's the question that I've got to ask each of you. Do you agree without reservation to comply with any request or summons to appear and testify before any duly constituted committee of Congress should you be confirmed? Let's just go right down the line. We'll start with you, Mr. Crowell. Mr. Nash. Mr. DeBono.
Without hesitation.
Mr. DiLorenzo.
Absolutely.
Judge Goode. Mr. Lean.
Yes.
Ms. Macy.
I do.
Mr. Timmer.
I do.
Senator Blumenthal.
What made this hearing stand out wasn't just the nominees' qualifications, it was Senator Josh Hawley's insistence on getting clear answers about public safety. Throughout the exchange, Hawley repeatedly brought the discussion back to violent crime, asking each nominee how they would protect communities, deter repeat offenders, and handle sentencing. When one nominee's previous comment that there is no rehabilitation in prison surfaced, Hawley pressed for clarification, giving viewers a clearer understanding of how that perspective would affect real-world sentencing decisions. The hearing also highlighted Hawley's focus on another major concern, the growing backlog in the D.C. court system. He challenged the nominees to explain how they would move cases efficiently so that victims receive justice without unnecessary delays while defendants receive a timely day in court. Whether you agree with every answer or not, Hawley's questioning kept the focus on accountability, public safety, and the responsibilities that come with serving on the bench. If you enjoyed this breakdown, be sure to like the video, subscribe to America Brief, and turn on notifications so you never miss the biggest moments from Congress and the Senate.